Hello everyone, welcome back to my channel. Before watching this video, don't forget to like, comment and subscribe. Now let's start this video. The Supreme Court Maritime Law and the Offshore. The decision of the Supreme Court of Canada in Bourne Valley Husky Ltd 5 St. John Shipbuilding Ltd confirms that many aspects of oil and gas operation in the Canadian offshore are governed by Canadian maritime law. Additionally, the decision attempts to clarify some of the issues related to recovery of pure economic loss and the scope of manufacturers' duty to warn. This article considers the implication of applying Canadian maritime law to the Canadian offshore using the Bow Valley decision as a backdrop. The rig was chartered to Husky Oil Operation Limited or HOOL and Bow Valley Industries Limited or BVI. Depending on the location of the rig, either the Husky Oil Operation Limited charter or the Bow Valley Industries Limited charter will be in effect. The charters had essential terms. The charters has essential tenants. The rig was crewed and operated by BHAB with Husky Oil Operation Limited and Bow Valley Industries Limited having the right to direct where the rig has to drill. While drilling in offshore found land, a fire occurred on the rig, which was participated by the wire and wrap. A trial and in the found land court and appeal, BVHB has found 60% contributory negligence and remaining 40% was divided equally between the yard and Raysom because of their failure to warn BVHB that the work would burn. Reduced to its essential, the Bow Valley decision confirms the following. First, most contract and tort claims arising offshore will be governed by Canadian maritime law. Second, it will be very difficult for charterers or others to recover against third parties in respect of claims which are purely economic in nature and not found upon a direct claim for physical damage. Something which happen at sea are obviously maritime. Some of the more obvious examples include collision between ship, salvaging vessels in trouble and carrying containers by ship from one port to another. In order to fully appreciate the broad-reaching scope of Canadian maritime law, it is useful to review its elements as defined and refined by the Supreme Court of Canada. It is important to understand that the court looks at maritime matters in the context. There are some activities which would not obviously appear to be maritime, but which have been so characterized by the Supreme Court of Canada. The theft of calculators from a storage shed in Montreal following discharge from a ship would not necessarily seem to be maritime. A loss on board a vessel caused by a manufacturing defect in a product made onshore and used in many industries besides shipping might not appear an obvious candidate for maritime status. But the Supreme Court of Canada has found both the situation to be maritime. Maritime contracts will also be governed by Canadian maritime law. A contract to build a ship is maritime. Certainly, a contract to build an offshore drilling rig would be similarly characterized. Drilling contracts used in the offshore are maritime and would be subject to the application of the principle of Canadian maritime law. Maritime law is also uniform from coast to coast. Statutory laws of the provinces do not form part of maritime law. For instance, to the extent that the provincial legislatures have addressed this issue, most provincial statutes dealing with the registration of cattle mortgage exclude ships registered under the Canada Shipping Act. Provincial statutes which provide for the calculation of interest, whether the prejudgment or otherwise, are not applicable to litigation governed by maritime law in which interest is calculated in accordance with the relevant case law. Drilling contracts for the offshore are to be characterized according to the principle of maritime law. Most drilling contracts involve the leasing of a drill rig from a drilling company to an oil company. For the most part, the crewing of the rig is the responsibility of the rig owner. The person on board the rig will carry out both traditional maritime functions such as master, chief, engineer, and non-maritime function, the drilling crew. In addition, the oil company client will from time to time have a number of people on board the rig carrying out various functions: wireline, mud, engineering, cementers, and directional drilling personnel. A drilling contract is usually for a specified period of time, often being the amount of time anticipated to complete the exploration program. In maritime parlance, this would qualify as time charter, by which a ship is leased to a charterer, but the responsibility for operating the ship remains with the ship owner. The undertaking of seaworthiness. There is an implied undertaking in a time charter that the ship is seaworthy. Whether or not the charterer can treat the charter as discharged by reason for a breach of this undertaking depends on the extent of the breach. There are several important aspects to this undertaking which are relevant in drafting drilling contracts. First, the required seaworthiness is relative to nature of the ship. Second, the ship must be fit in the sense that is fit to deal with the ordinary perils to which it is likely to be subjected. Third, the standard of seaworthiness may be affected with improved knowledge of shipbuilding. Fourth, the competence of the master and crew is a consideration in evaluating seaworthiness. Fifth, a ship owner will be liable for loss caused by breach of the seaworthiness obligation. Sixth, this obligation may be avoided by suitable contractual wording. It is important to have a sense of maritime cases dealing with this aspect so they can be considered in interpreting the seaworthiness provision of drilling contracts. The unusual sort of representation in a drilling contract may be in the following terms. First, contractor's equipment will be in good working order. Second, whereas contractor is engaged in the business of drilling, testing, and completing, working over and deepening of wells, represents that it has adequate resources and equipment in good working order and fully trained personnel capable of efficiently operating such equipment. Insufficient in the required number of crew members has also been found to constitute unseaworthiness. In the Haynes Horn, the Fifth Circuit Court in the United States found a vessel unseaworthy due to the following crew insufficiencies. First, the captain was ill, did not supervise loading, and left the vessel before the end of the voyage. Second, at no time during the voyage did the vessel have the normal complement of officers. Third, the officers had no experience with the cargo in question. And fourth, once the captain left the ship, the vessel had only two mates. Maritime law provides that injuries caused to a person as a result of damage or injury caused by the ship will be accorded the status of a maritime line. Personal injury sustained a person on board a ship as a result of negligence in the operation of the ship, although giving rise to claim in rem, would not give the plaintiff maritime line status. The claim of a driver injured by the paddle wheel of a steamer would be accorded maritime line status, whereas a claim for personal injury sustained as a result of falling down into a hold of a vessel would not give maritime line status. For the plaintiff, whose personal injury claim can be construed as caused by the ship, the maritime line status of claim is significant. In essence, it means that the plaintiff can commence an action against the rig and have it erased regardless of whether the owner of the rig will be able for the accident. Okay everyone, that's all this article today. Thank you so much for watching this video. Until the next one, bye bye.